For admission, item number 1.
May it please your lordship. Now here in this case, my lord, the background of this case is this, that a person has been murdered, causing the number of injuries and which are in a very brutal manner, for which these accused persons from time to time were arrested and several bail application was preferred. Now, during the course of a bail hearing, my lord, the state government has taken a conscious decision, considering the materials on record, to transfer this case from Mokokchung to Dimapur district for trial. Now, on that particular point, my lord, Honorable Justice Devashish Borua referred the matter to the division banks to decide with regard to the power of the state government. Now, that's been answered by the learned counsel for the respondents. Even then, my lord, this petition has been preferred as a transfer petition suo motu, being 4 of 2023. So under the CRPC, my lord, I will confine with regard to the provisions of CRPC only. Now the CRPC gives a mandate and the power to this honorable court to suo motu transfer a matter. Am I audible, my lord? Hello, am I audible?
No. Now audible.
Yes. So what I am on, my lord, this matter, my lord, arising out of a bail
You are not
application.
audible.
Am I audible?
Yes, now.
Yes. So, my lord, I am starting from the inception, my lord, wherein, my lord,
You are not audible.
Not audible, my lord.
Now audible.
This matter, my lord, arising out of, my lord.
You are not audible. You are not audible. I think you have to give physical presence. Why this is always giving us disturbance?
Am I audible now, my lord?
All of this the network connection is not very good.
Here, my lord, it's been shown network connection is very strong, my lord.
You are not audible. You are not audible.
That's the problem, my lord. May I try with another gadget, my lord? If your lordships allow me, my lord, or laptop. Yes, my lord. Julian.
It's completely gone.
Am I audible now, my lord?
Yes.
Yes. My lord, here is a case wherein, my lord, from the inception, I am making a submission wherein a person was arrested.
You are not audible.
Oh, I'm trying another number, my lord.
Why don't you give physical presence? Gauhati is not far. Road condition is very good.
My lord, I'll
We
try.
are facing this network problem for quite some time.
My lord, I try my luck for
You
one
are
time
not audible.
only.
You are not audible.
I try my luck, my lord, by another gadget, my lord. Let me try last time, my lord. Otherwise, my lord.
You can give your time. We have SB matters fixed.
Oh, my sir.
Come tomorrow. We'll hear you. We'll hear the other side today.
Tomorrow I'll try my luck through online only, my lord.
Come tomorrow. We will hear the other side today and we'll hear you tomorrow.
My lord, my lord,
Okay.
my lord.
Can you make it sure?
Tomorrow by physical presence, it will be not be
Because
possible.
you are not audible.
Tomorrow I'll try my luck, my lord, through good connections, my lord, if it is possible, my lord.
No, then we cannot waste our time keeping it parted.
Ah. I say. Let the other side submit, my lord. I am trying my luck through another, my lord, laptop connection, my lord. I say.
Okay, sir. Who is to start?
Yeah, please, Lordship.
Yes.
I'm appearing for accused 3, 8, and 9.
Who is accused 1, 2, and 3?
Accused 3.
Let us come serially. Yes.
Yes, my lord.
202.
I'm for the accused 1, 2.
One, two, four, five, 6, 7.
5, 6, and 7.
Yes. Why are you objecting to the transfer?
Yes, my lord.
Give us that ground. Where have you stated in your affidavit? Take us to that.
Order number 4, my lord, in my affidavit in opposition.
Your affidavit, your respondent number 1, 2, since para number 4. Affidavit on behalf of accused person, namely Mr. You're for this Mia Lebden and all this?
Yes, my lord.
Mia Lebden Tongpok Sangba.
Bendang Sanap.
You're for all this?
Yes, my lord.
So these are the accused 1, 2, 4, 5, 7, 6, and 7.
Yes, my lord.
Yes, why are you opposing the transfer?
So, my lord, in the present case, trial has been already delayed for nearly 1 year.
That's all right.
The accused are in custody without trial. CC has been conducted. Charge has been framed against them. But till date, trial is yet to commence.
Yes.
Not even one witness has been examined.
I'm asking you, why are you objecting?
So, my lord, the allegation is there is no ground for transfer, my lord. There is no ground to transfer this case. There are 45 witnesses and trial will be delayed.
That's all right. Regarding witnesses, you leave aside. We are asking you, why are you objecting to the transfer? Why?
On this ground, my lord, the trial will be delayed if the case is transferred. Trial has already been delayed by 1 year and it will further delay trial. If it is transferred to any other district,
Do you think that the transfer court is a delaying court?
no, my lord.
Huh.
However, all the witnesses are from Mokokchung.
Okay.
Yes, basically on this ground, I'm objecting, my lord.
Which
are not on bail.
which para have you stated in your affidavit?
At para number 8, para 6, and para 6 also, Your Honor, my lord. Great inconvenience will be caused to the witnesses. They will incur huge financial burden, and there will be delay in trial. And delay in trial will not only cause injustice to the accused, but also to the victim, my lord, to the family of the victim, if there is delay in trial, my lord. Therefore, my most humble prayer is that a speedy trial be conducted at District and Sessions Court, Mokokchung.
That's all.
That is all, my lord.
If I may, my lord.
Hmm.
And for accused number 3, 8, and 9, my humble submission is that, my lord, the order dated, which is passed by the Department of Law and Justice, is illegal as much as it is beyond the power of the executive to transfer the criminal proceedings.
We have crossed that stage. You tell us now.
Yes, my lord.
Why are you objecting to the transfer?
I'm objecting to the transfer because, firstly, the manner in which the criminal proceeding is transferred is illegal. And if this honorable court, instead of protecting the law, which is provided in section 407 of the CRPC, if this court condones the act of the executive,
Right.
which is the Department of Law and
আচ্ছা
Justice,
তাতে যাই পেলাই হ'ব নেকি?
it means allowing the executive to interfere in the dispensation of the criminal justice.
What is the illegal act of the executive? What is the illegal act of the executive?
The executive has transferred the criminal proceeding.
That stage is already over. Stage is already over. This court has held that under CRPC.
My lord,
This court has the competence.
this court had decided that section 31 is applicable. That is already decided. But what I want to point out,
It is not applicable.
what I want to stress is that if this honorable court allows a transfer, which is already allowed beforehand by the executive, and if my lord, may kindly peruse the order
Mr.
211/2023.
Why are you objecting to the transfer? That is the only issue we have to decide now. What is your apprehension that if there is a transfer of the case, illegality will be committed, or there will be biasness, there will be injustice? Why?
Of course, my lord, there will be a huge financial burden
Ah.
in terms of finance and
Okay,
logistics.
where have you stated in your this thing? Where is
On
your
para 6.
affidavit?
On para 6 of my affidavit, on
Which
page 4.
affidavit? This is affidavit of.
This is a criminal case, whether your witnesses are also coming.
Yes, my lord.
How? Prosecution witnesses basically are against you. All the prosecution witnesses. Why should you worry about that?
My lord, in the interest of fair trial, I'll be bringing my. It's under preparation. Yes, my lord.
Tang Mayang, Mr. Lipok
Yes, my lord.
Tanse.
Yes, my lord.
3-8. Yes. Okay, yes, we will continue. Continue. Yes, continue, sir.
Yes.
Subsection 2 of section 407 clearly states that the High Court may act either on the report of lower court or on the application of the party interested or on its own initiative.
Or
Provided
what is
on its
the-
own initiative.
on its own
Yeah, I'm
initiative?
coming, my lord. I'm coming, my lord. Provided that no application shall like the High Court for transferring a case from one criminal court to another criminal court in the same session division, unless an application for such transfer has been made to the session judge and rejected by him. This was never done. Straight away, Department of Law and Justice transferred the criminal
What
proceeding
about the case, High Court on its own motion?
because the High Court is compelled because the Session Court Makutsung have written a letter to the Honorable High Court.
That is on the transfer made by. the
Yes, my
state
lord.
government.
My lord, what I'm apprising this Honorable Court is that if this Honorable Court allows transfer, it is encouraging such act for the executive to interfere in the near future.
Where have you stated in your affidavit?
On para 7, that the answering deponents therefore humbly pray that this Honorable Court may be pleased to pass necessary direction for trial to proceed in Sessions Court Makutsung, failing which will result in abuse of process of law and interference in the independence of judiciary by the executive as evident by the order dated 13/10/2023.
That is only your submission. That is not the
Yeah.
ground. That is only your submission.
This is also one of the ground for not transferring.
Okay.
A person of influence can approach government to transfer in the near future. And my question is, will this Honorable Court take sumo motu again and again in all the transfer case in the near future?
It would
There is
depend-
abuse of process
it would
of law.
Depend on the facts and the circumstances of the case.
We can't deny murder has been taken place. We can't deny. But
No, I mean the
we must
transfer.
look into the process of law. This is a question of process of law. I'm not arguing on the facts and circumstances of the case. A person has lost his
Are
life.
you against the
I'm-
suo motu transfer made by the High Court? Are you against that?
Yes, my lord.
Are you against that?
Yes, my lord. My prayer.
What is your ground? Where is your ground? Where you have stated that the suo motu transfer made by the High Court is illegal? Where is the ground?
The order dated 13/10/23, I have cited in my affidavit. That itself is my opposition to the transfer, my lord. I'm
What is
praying
your-
to set aside, to cause and set aside the order dated 13/10/23 and let the proceed.
Yes, any citation?
Yes, my lord. 2006 SEC 204, para 7.
2006.
6 SEC
2006, volume
6
6,
SEC
2006, 6.
2000 volume 6, page 204. On para 7.
2006, 6 SSC, page,
No, my lord, 2000.
that's
Break
why
it, 2000.
2006. 2000, volume 6,
Yes, yes, yes.
huh? SSC, page,
204.
okay. Para,
On para 7, my lord.
Read, these are all principles of law.
Lord, the purpose of the criminal trial is to dispense fair and impartial justice uninfluenced by extraneous consideration. When it is shown that public confidence in the fairness of the trial will be seriously undermined, any party can seek the transfer of case within the state under Section 407 and anywhere in the country under Section 406. The apprehension of not getting a fair and impartial inquiry or trial is required to be reasonable and not imaginary based on conjecture and surmises. It is if it appears that the dispensation of criminal justice is not possible impartially and objectively and without any bias before any court or even at any place. The appropriate court may transfer the case to another court where it feels that holding of fair and proper trial is conducive. No universal or hard and fast rules can be prescribed for deciding a transfer petition, which is always to be decided on the basis of the fact of each case. Convenience of the parties, including the witness to be produced at the trial, is also a relevant consideration for deciding a transfer petition. The convenience of the party does not necessarily mean the inconvenience of the petitioners alone who approach the court on misconceived notion of apprehension. Convenience for the purposes of transfer means the convenience of the prosecution, other accused, the witnesses, and larger interest of the society.
That is why we are going to examine whether actually transfer will be in the interest of justice or not.
Yes, my lord.
Yes. We have not examined.
Yes, my lord.
Yes, anything more?
Am I audible, my lord, now?
Just wait.
Yes.
Here, my lord. On the ground, there is no communal tension, my lord.
Where is the ground taken by you against transfer in your affidavit in opposition? Which para?
Para 4, my lord.
The provisions of section 407 CRPC clearly states that the power to transfer case within the state lies with the High Court of the concerned state. We are here, that's why.
Yes, my lord. High Court has power to transfer.
We are
What
here.
I'm stressing is that in case the High Court, dishonorable court transferred this criminal case, it is condoning the act of the executive. Because if executive had not transferred the criminal case, okay, fine, I have no objection, my lord. I leave to the discretion of this honorable court. If the executive have not transferred, but prior to the cognizance suo motu, the executive have already transferred. There cannot be two parallel law in one state. The state is saying under Rule 22C of the Rules for Administration, they have transferred.
Mr.
Again, now if this honorable court again transferred the criminal proceeding, there is two law in one state, my lord.
It seems you are confused. You are confused.
I'm not confused, my lord. It is very clear.
This case was tried by Session Judge Mukuktum,
Yes, my lord.
correct?
Yes, my lord.
And in the midst of the trial, on the application submitted by the victim,
Yes, my lord.
the government has transferred the case
Yes, my lord.
to District and Session Judge Dimapur,
Yes, my lord.
correct?
Yes, my lord.
On the order issued by the government, the District and Session Judge had written the letter. They had actually brought that information to the notice of the registry of this court,
Yes, my lord.
correct?
Yes, my lord.
the registry referred the matter to the principal seat. Correct?
Yes, my lord.
The principal seat was of the opinion, the Honorable Chief Justice was of the view that this should be taken up so moto. And also to decide the issue as to whether the government had the competence to transfer the keys. This court has held that under CRPC, this court has the competence to take up the matter so moto. That is why we are here. Why are you banking again and again on the illegality committed by the government? That chapter is closed. We are now here to decide as to whether the transfer sought for by the victim is proper or not. And you are actually challenging the stand taken by the victim that the case should be transferred. That's why we are asking you again and again, what is the ground of your challenge not to transfer the case? That is why we are banking on that. We are not asking you whether actually the government has committed an illegality in transferring the case to the district and session judge Dimapur. That chapter is closed. That's why we are asking you again and again as to what is your ground opposing the transfer made by the informant. That's all. That's why I'm asking you. We are asking you, where have you stated in your petition, in your affidavit, on your ground objecting to the transfer? That is what this court wants. You are not addressing some school boys. You are addressing the High Court. We understood. And we want to know from you, what is your ground objecting the transfer? So don't go back again and again and again as if we have not understood. We have understood the case A to Z. We have understood the facts of the case A to Z. We want to know from you as to what is your ground objecting the transfer. That's all. That's why I'm asking you, kindly take us to your affidavit to satisfy us as to what is the ground objecting to the transfer.
Lord, the accused person will face immense hardship in terms of finance and logistics to prepare for the trial.
Where have you stated that?
On para 6, my lord.
Para 6.
Accused and their family members will face immense hardship in terms of finance and logistics to prepare for the trial.
Yes.
My lord, further, there is no communal tension on the ground. If the trial is held in Dimapur, the accused family members have to travel now and then, and the trial may take many years to conclude. And the accused are all from a weak economic background, my lord.
Yes, okay, next. What is your ground?
And lastly, my lord, if this honorable court allows a transfer, in the near future, a person of influence can anytime approach the executive and transfer their personal case, my lord. And this submission may also be recorded, my lord.
Mr. Counsel. We have already conveyed to you that that chapter is closed. You cannot say, you cannot make a submission before the court that in future too.
Yes, my lord.
Let the future come. The court will decide.
Yes, my lord.
We now decide on the issue which is before us.
Yes, my lord, the abuse of process of law that committed by the executive may be recorded in my submission, my lord. By passing the order dated
When this court has already
13 October
recorded,
2023.
when this court has already recorded that under CRPC transfer is permissible. Do we have to impose your views on the views taken by the court? Yes,
Yes, my lord, it's my humble submission.
yes, state respondent, let us see.
Lordship, though the order transferring the case from Dimapur to Mokokchung to Dimapur, Your Lordship, though it's now clear that the state does not have the power. But before we took this decision, Your Lordship, we have saw the views and comments from the Deputy Commissioner Mokokchung, the Superintendent of SP Police from Mokokchung, as well as the PP from Mokokchung District Court. And they all have expressed the view that if the case is not transferred, Your Lordship, there is very likelihood that the fair trial as well as the proceeding of the trial will not happen. Yes, Your Lordship.
Where are those,
In my affidavit, Your Lordship.
affidavit of respondent number one? The respondent one.
Yes, Lordship.
Affidavit.
In page 11, Lordship.
Just wait, just wait.
Page 11, Your Lordship.
Is the affidavit dated 29 February 2024?
Yes, Lordship.
Okay, well, got it.
Date. 11.
29.
No, no, the- yes, sir.
This is the affidavit of
Yes, sir.
Page 11, we have written to the Deputy Commissioner.
Just wait, just wait.
We have written to the Deputy Commissioner to give his views and comments with regard to the transfer of case from the jurisdiction of Mokokchung. Then page 12, we have written to the Superintendent of Police.
Can you kindly read page 11?
Yes, to the Deputy Commissioner Mokokchung Nagaland, subject request for comments with regard to the transfer of case number such and such. Sir, the department is in receipt of an application from Dr. Maya Junda, Jamir Enclose, the sister of the deceased victim, praying for transfer of case from the jurisdiction of Mokokchung district in the interest of justice, citing that there is apprehension of pressure and interference from the opposite party, that is the alleged accused, if the trial proceedings are held in Mokokchung court. On the above cited subject, I am directed to request your authority to give your considered views and comments with regard to the transfer of case from the jurisdiction of Mokokchung court. This is on 11th of August 2022.
Yes.
Then again, the same letter we have written to the page 12 to the Superintendent of Police Mokokchung.
Okay.
Then again in page 13, we have written to the Public Prosecutor Mokokchung, Lordship, the same letter.
Yes, what was the reply?
And the review, Your Lordship, is in page 14. This is the Assistant Public Prosecutor view.
Just wait, just wait. Please read.
21st August 2023, Madam, with reference to your letter number such and such, I have the honor to submit herewith my views, comments regarding the transfer of the above mentioned case from the jurisdiction of Mokokchung Court. That, Madam, the accused person who were arrested in connection with the above mentioned cases are lodged at Mokokchung District Jail. Charge sheet against the accused person are filed by the investigating agency and trial are about to commence. However, considering the report made by APP such and such about the incident happened on 20 July 2023 outside the court, and keeping in mind the volatile situation in this case, there is an apprehension that the court proceeding may be effected in future. Hence, from the reason projected above and for fair trial, it may be in the interest of justice to transfer the case from the jurisdiction of Mokokchung Court. Then page 15 is the APP Lordship letter. Then page 16 is the Deputy Commissioner letter to the Secretary, 13 September 2023. Madam, with reference to your letter number such and such, and in reference to the subject cited above, I am to stake and enclose herewith a copy of the Public Prosecutor Mokokchung Nagaland with regard to transfer of case in connection with such and such. The case is found to be sensitive and that the court proceeding may be affected in the future also. As such, the case may be considered and be transferred in order to avoid any untoward situation. This is for your kind information and necessary action, please. So thereafter, the stake, we have brought the order transferring the order, though in view of the Honorable Division Bench of this Honorable Court, the stake do not have the power, Lordship.
So on the basis of the views furnished by the this prosecution, the deputy commissioner and all
And
this,
yes, Lordship,
the government had passed this
Yes,
order dated
yes.
13 October 2023.
Lordship,
Though this order is no more relevant.
yes, Lordship.
Yes, ma'am.
That's all, Your Lordship.
May I submit, my lord, if I am audible, my lord?
Yes, yes.
Yes. Very, in a nutshell, my lord, I'll place before this honorable court that the power of transfer with regard to High Court is for a fair trial, my lord. That is the very objective of 2006 judgment, which my learned friend for the other side has cited in paragraph 7. That is the principle that has been laid down.
Now that is
In
the
paragraph, yes, that's the yardstick by which this court will judge this case on the facts of this case. Now, the facts of this case is that on record, the learned public prosecutor has supported the case to the extent that there are reasons on record, because there is an affair when the victim's family, the informant, went to see the court proceeding. these accused persons, my lord, threatened with regard to taking off their lives. That is on record. And by way of an affidavit, that FIR copy, my lord, Honorable Chief Justice has asked me to bring it on record. I have brought it on record. Next thing, my lord, with regard to the submissions made by the other side, that, my lord, logistic, my lord, lack of logistic, lack of finance, no commutations, weak background, my lord. For it, my lord, our law is very much clear that a person who cannot afford legal this one to finding a good lawyer, the state would provide, my lord, legal aid with regard to this, and nobody can be prosecuted without giving, my lord, legal aid, my lord. And legal counsel has been part of this whole system of our judiciary, wherein it provides it. If they cannot avail and meet the expenses, my lord, it is upon the accused person to get the legal aid, my lord, which is very much there, my lord, as per the law of the land. Now, with regard to the number of witnesses, my lord, one learned counsel for the accused person made statement that all witnesses are from Mukukchang, my lord. That is incorrect, my lord. I did my due diligence, my lord, as for record.
You are not audible. You have closed your eyes. Nothing is said. Anyone assisting the counsel from Gauhati? Yes, you submit. You make your submission.
May I please, Lordship? Your
Yes.
Lordship, I'm not well acquainted with the facts.
That is your submission.
I'm just here assisting them. So
You read the file and come tomorrow. You read the file and come tomorrow.
Your Lordship, the file are not with me.
It's all
There.
right. We'll direct the registry to give you copies of the petition. You read your affidavit and come. You read
Yeah.
your affidavit and come.
My lord, am I audible, my lord? I'll sum up, my lord, within 5 minutes, my lord. If I am audible, my lord.
Yes.
My lord, out of 45 witnesses, my lord, 21 witnesses are government officials, out of which 2 are from Gauhati, my lord. They are nodal officers of 2 service provider, mobile service providers, my lord.
Where have you stated all the submission? Where have you stated all the submission?
No, that is a, my lord, matter of record which appears from the charge sheet itself. And 7 witnesses are from the victim sides, my lord, who are apprehending that they would be subjected to.
The charge sheet is part of your affidavit.
No, my lord, that's been matter of record in the charge sheet, my lord. Yes.
Whether charge sheet is a part of your affidavit.
My lord, charge sheet has to be, my lord, part of this, my lord, the records, my lord. If your lordship wants to see the records, my lord, record is to be called into. But your lordship can note down my argument, because, my lord, it's a matter of record that 21 witnesses are government witnesses, out of which 2 are telecom nodal officers from the service providers who are from Gauhati, my lord. And they have no problem with regard to adducing evidence in Dimapur, my lord. 7 witnesses, my lord, who are filling the barge, my lord, because their family members have brutally been murdered. And out of, my lord, rest of the witnesses, my lord, another 4 witnesses are from Dimapur itself, my lord. So what I am on, the law and of the land, my lord, of our nation has taken care of with regard to whatever submission been made by the accused counsel, my lord, that logistic with regard to finance, there is legal aid provisions, my lord, wherein it can be. 2018.
Yes.
And, my lord, another judgment I rely in, my lord, 2018-7 SCC, my lord, that starts from page 339, my lord. I've asked my local council out there to furnish a copy, my lord, wherein it's a recent judgment of Justice K.V. Ramanna and Justice Abdul Nazir. Relevant is paragraph 24, my lord. May I read it, my lord? Paragraph 24 is the relevant, and that's the law of the land, my lord. Paragraph 24. As justice should not only be done, but also seems to have been done, it would be necessary that the trial should take place in a fair and transparent manner, wherein there should be no element of bias or witness tampering. As the appellant has clearly made out a case for transfer, we are inclined to accept the prayer sought by the appellant in this case. Accordingly, it has been allowed, my lord. So that's the principle of law. In Mukokchang, my lord, we are handicapped because we are in minority, and that time, my lord, during the proceeding after killing of my brother, my lord, a live ammunition has been thrown in nearby compound, for which I have lost the affair. Police has investigated.
Or have you stated in your
Yes, yes, my lord. These facts has been brought on record.
Please,
Yes,
don't interrupt. Don't interrupt. Please
My
listen
lord.
to this code. Where have you stated in your affidavit supporting the transfer?
yes, yes. My lord will kindly come to the last, my lord, that transfer affidavit that has been filed on 2nd of August 2024 in view of Honorable Chief Justice order, my lord, that I have brought on record, my lord. All documents has been produced, my lord.
You know,
My lord will kindly come to page 3, my lord.
page 2nd of August 20.
Yes, yes, yes. Page 3, para 3, my lord.
Please wait, we have not traced.
Yes.
Second.
It's in the form of additional affidavit, my lord. Respondent number 2.
Fifth August.
Maybe 5th August, my lord. Yes. Affidavit has been sworn in on 2nd August, my lord.
5th August. Is it additional affidavit?
Yes, my lord. Yes.
Additional affidavit.
Additional affidavit by respondent number 2.
In compliance to the order dated 13.
Absolutely, my lord. Absolutely.
Where have you stated?
Yes. My lord will kindly come to page 6 of the affidavit, paragraph 6, my lord. Besides the other relevant documents enclosed in the said letter, the respondent also enclosed the FIR dated 11 June 2023, which she filed before the officer in charge so-and-so Mokokchung, Nagaland, informing the police about the poly bag containing waste bag placed in the vicinity of her compound. The item recovered were handed over to the police, wherein the seizure memo has been done. 2 misfired NMM live ammunition, 1 small knife, 15 numbers of marbles, 17 numbers of iron fishing net balls, 2 lighter, 2 Equirex tablets, 1 small size bandage roll, 1 brown shoe lace, 1 camo Adidas waist bag, my lord. This has been brought on record, my lord. By way of an affidavit, these are the FIR, my lord. And the photographs and everything has been, my lord, annexed. My lord, again at page 12, my lord, of the affidavit, my lord, paragraph 13, my lord, it has been stated, my lord, with regard to what has happened, my lord, in the court premises, my lord.
Yes.
Another page 12, my lord, will kindly see paragraph 13, my lord. What happened in the court proceeding? The
Page-
respondent also brings to the kind notice of this honorable court FIR dated for
Page
page
12.
12, yes, paragraph 13, my lord. The respondent also brings on to the kind notice of this honorable court FIR dated so and so, filed by her mother before the officer in charge of police station so and so under the subject report of threat against the family of late so and so. The respondent mother filed the FIR following the incident of threat and intimidation. It so happened that on 13 October 2023, after the court proceeding, consideration of charge as the accused were taken by the police in the prison van, some of the accused persons shouted at the respondent's mother and his families, who was standing outside. One of the accused persons threatened them by screaming at the top of their voice in Ao dialect Lalevodi, meaning will come out. Onlookers were also witness to this incident, and it was also recorded in the video. The respondent mother also stated the facts in the affair that even after the gruesome murder of her son, the accused person are still pursuant to hammering her and her family and their sympathizers, my lord. This is a clear case, my lord. A fair trial cannot be held at Mokokchung, my lord. I would pray with folded hands, considering the law of the land, my lord, and whatever, my lord, under the law is entitled to the accused persons with regard to legal aid, if they are not uh, uh, belong to the creamy layer of the society, my lord, legally it is there, my lord, to take care of this, my lord. For the interest of justice, for securing ends of justice, a fair trial is a must. And as such, my lord, the materials on record, my lord, proves it that on repeated occasions, these accused persons file bail application. After perusal of this case diary, my lord, repeatedly, my lord, it has been rejected. Why, my lord? Considering the material, that gruesome manner, and how the accused, it was a conspiracy, my lord. That has to be taken into account, my lord. And I am very obliged to this honorable court for accommodating me to that extent, my lord, so after so much of disturbance also, my lord. I sum up with my argument that fair trial can be only possible in Dimapur, my lord, wherein it will be that fear element will be eliminated, my lord, and justice will prevail, my lord. That's my respectful submissions, my lord.
Why only Dimapur?
My lord, according to
Why
the
not Kokha? Why not the other districts? Why only Dimapur?
my lord, Dimapur happens to be, my lord, with well, my lord, infrastructure and, my lord, that police machineries and all, my lord. And as such, my lord, they want it in Dimapur, my lord, because these victims' family members also resides
You are
in
not
there, my
audible now
lord,
again.
my lord,
Yes.
and victims' family member, and they feel secure there, my lord.
Kohima also has all the infrastructure, proper court, proper policing, proper security, proper jail. Why,
That is there.
why your special preference for Dimapur?
My lord, according to the informant side, my lord, they feel secure in Dimapur, my lord. That's been, my lord, been communicated to me. And with regard to Dimapur, if it happens, my lord, their family members are there, so that at least that secure part, my lord, they want that particular pair. And it is wisdom of this honorable court, my lord, whatever it is, my lord, whatever, my lord, feels like better, so that fair trial can take place, my lord. I leave it to the wisdom of this honorable court, my lord.
heard MSV Sokri, the learned. Here you were appearing as additional or public
PP.
prosecutor?
Public prosecutor, Lordship.
The learned public prosecutor for the state respondent number one. Mr. Your good name?
A.K. Bhuya, my lord.
A.K.
Bhuya, my lord. Difficult to pronounce, my lord.
A.K. Buyan.
Yes,
A.K. Bhuyan. Bhuyan,
yes.
the learned counsel for the respondent number two victim. Victim slash informant. Mr. Your good name?
A. Sophie, my lord.
A. Sophie for the accused number
A1, A2, A4, A5,
1, 2,
4, 5, 6, and 7.
1, 2, 4, 5, 6, and 7, and Mr. So-and-so
For
Learned
accused
counsel.
person 3, 8, and 9.
for the accused number
3, 8, and 9.
3, 8, and 9. The learned counsels at length. Judgment in order. Reserved.
My lord, the appearance of S. Mary also may be recorded.
Okay. Uh, How the MS, this V. Sokre, the learned public prosecutor for the respondent number one, along with S. Mary,
Yes, Lordship.
the learned senior government advocate.
Lordship.
Deeply obliged, my
Right, my lord.
Yeah.
May I please, my lord?
Yes.
Lordship, may kindly allow me to make a mention on for item number 29. 29.
Yes, please.
My lordship, may kindly leave this matter after a week, my lord.
29,
29, my
the
lord.
hearing
Hearing matter, my lord.
on the prayer of Mr. Nandan, the listener government advocate, listed up to.
I'm deeply obliged. my lord.
Lordship, I may be allowed to mention for listing of the case on Monday, Lordship. The matters will fix on
Monday,
Yes, Lordship. The case is fixed on 24, that is Tuesday, Lordship. However, I have some difficulties on Tuesday. If it can be postponed to 23, Lordship.
what about the other side?
I have to be consent of the department.
Okay. Okay.
Obliged, Lordship.
May it please my lord. I beg to mention items 17 and 18. I've received instructions, however.
Let it come as per the list. As per the list.
Please, your lordship,
Yes.
I beg to mention hearing item number 27. Lordship, kindly allow this matter to be listed on 19.
What is so auspicious on 19?
Lordship, today my senior has some personal difficulties.
There's
So-
urgency, matter pertains to non-settlement of family pension.
Non-settlement of?
Family pension. Lordship, my learned friend Josia is agreeing for respondent for AG. Lordship, so far as the accountant general is concerned, Lordship, they file affidavit in opposition and the accountant general has sought from the government to furnish the necessary pension papers. So there is limited role so
Okay.
far as the AG is concerned. It is the respondent, it's the respondent.
This is item 20.
27.
So on Thursday, Lordship, 19.
MS Censor. Learned Counsel. Explanation on behalf of Mr. Joshua Shakti. The learned counsel for the respondent number 4 and 6 adjournment of the case on 19/9/2024. Listed accordingly. Okay.
For motion. Item number 1.
If I may please, your lordship.
You were the one who met with an accident.
Lordship. So, lordship, due to that account, the appearance could not be made in the original writ petition for which this current application has been filed for restoration, your lordship.
MS. Kezosano Kiki. Learned counsel for the applicant. / writ petition. The present writ petition has been filed. The present application has been filed. Under Order 9, Rule 9 of the Civil Procedure Code 1908, seeking for restoration of writ petition number 94/2023, which was dismissed by the Honorable Court by order dated 7/6/2024. The result. As to why the writ petition will not be prosecuted from the date fixed by this court. Has been explained in paragraph 4 to 8 of the application. So, this court has perused the application, more particularly the grounds cited in paragraph 4 to 8 of the application, from which it is discernible that the non-prosecution was account of the injuries suffered by was on account of the injuries / fracture suffered by the learned counsel for the petitioner, for which the learned counsel had to be under treatment and medication. This court is accordingly of the view that the grounds for non-prosecution of the writ petition has been properly explained. So, in that view of the matter, the order dated 7/6/2024 passed by this court is recalled, and the writ petition number and WBC/94/2023 is restored back to file. Okay. I hear dismissed, disposed. Okay.
I'm grateful, Lordship.
For motion, item number 2.
Yes.
Yes, my please, Lordship. Lordship, application was filed by the respondent 8 in the petition. The appellant is the seeking what is Honorable Court's for repairing the gate and on the dispute land, Lordship. Since the building, Lordship, is in a dilapidated condition, and since the foundation of the property, moreover, the collection of water, which is causing unhygienic environmental situation in the neighborhood, and it is become an area of spreading vector-borne diseases like mosquito and all. So, Lordship, on the last occasion, Lordship has given the respondent some time, the respondent, the writ petitioner, some time to file some objective, or else this Honorable Court was inclined to allow the petition
Yes, what is your objection? Any objection you filed?
Yes, my lord, I have filed affidavit in objection. Lordship, here the applicant has projected that the gate, iron gate as well as the building is in dilapidated condition. However, Lordship, in my affidavit in objection, I've projected some pictures that appears to be a little different from what the applicant picture displays. So it's highly questionable whether this iron gate and the building is really in dilapidated condition or not. Thereafter, Lordship, my second
The,
objection
the,
is,
the applicant is not asking for repairing of the dilapidated, the building, only the gate. Correct?
Oh, yes, Lordship.
Only
Only the area where is need repairing, Lordship.
Only the area which needs repairing.
Lordship,
That will
Lordship.
be too vast, a liberty to.
yes,
grant
my
it.
lord, that's,
Or else it'll damage the building, Lordship, because the building
Ali,
might
if
fall.
I give you the liberty, the area where it is to be repaired, you will repair the whole thing.
No, Lordship,
Exactly,
no, Lordship.
No.
main-
Your application is also specific to the gate.
Gate, Lordship, yes, Lordship.
Yes, why now
At
the
paragraph
other
3,
areas
paragraph 3.
where actually like repairing is required?
That paragraph 3 and 4, Lordship. Lordship, make up the paragraph 3 and 4. It's at page 4 of my IA, Lordship. I may be allowed to read, Lordship. But the applicant observed the main iron gate of the building is in dilapidated condition, which requires immediate repairing. So also the lift shaft on the ground. We have dug a lift shaft.
What
on
is
the
that
ground.
lift shaft?
It's we have dug out the ground to install the lift. So it's on the ground and it's covered with, as of now, it's covered with water. So we need to cover that, or else it's breeding ground for the mosquitoes, Lordship, another vector-borne diseases. To avoid accidents and to avoid
Lift
spreading.
shaft. What is
Lift
that
shaft.
lift shaft on the ground?
Lift shaft, the lift for the area where we have to make the construction for installing the lift, electronic lift. So we have to dug up the ground also, at least 8 to 10 feet to install the machine and all for the foundation. So that area has been covered with water. So we need to cover that in order to avoid accidents and in order to avoid the breeding of mosquitoes and other vector-borne diseases. And the gate, Lordship. That only that part, Lordship. The foundation of the gate.
In your photograph, you have not shown the gate.
Lordship, page number 9.
Page number 9.
Yes, my lord. That's the gate, iron gate, the main entrance.
Oh, this is not
These
the
are the
house,
gates.
this is the gate.
Yes, my lord. It appears to be very fine. And I don't see any repairing which is required at this stage. Therefore, the picture which the applicant has submitted and the photographs which I've submitted shows a different image, Lordship.
Lordship may come.
Thereafter, Lordship, my second objection is with regards to the notice issued by the Kompura of Ward number 18. When the land in question.
This is the
is
main
still
entrance gate.
Lordship.
Yes, my lord.
Lordship may come to my IA, page number 9. Lordship, it's a close-up photograph, Lordship. In my IA, page number 9, it's a close-up photograph. That is the area. Exposure, due to some exposure, Lordship. We need to repair that part. Only that part, Lordship. The main, Lordship, the concern of the appellant.
This is to cover the
Lift shaft as well as the gate, the area of the gate, Lordship, iron gate. That's all. That's been described in my petition, Lordship, application, para 4 and 4, Lordship.
But Mr. The learned counsel for the applicant. And Mr. Imchan.
Ali Wazukam, Lordship.
I'm sorry, Mr. Ali Wazukam, the learned counsel for the
respondent number 1 in the IA.
the respondent number 1.
In the IA.
The respondent number 1, yes, the respondent / petitioner. And Mr. You cancel that first, and Mr. Bijmomi, the learned government advocate for the respondent number 2 and 3. By filing this application, no. So the present application has been filed to allow the applicant to undertake repairing works of the main gate standing on the premises covered by Pata number 1361 and the duct number 1423 of Dimapur town, block number 7, as well as to allow the applicant to cover the lift shaft which it is submitted why have you submitted this?
At paragraph 3, Lordship. The earth has been dug out, so the ground, left shaft grounds need to be covered.
What was the last one? Which? which it is submitted is to avoid accident and also to prevent breeding of mosquitoes. Mr. Fonseca has also taken this call to the notice dated 27/7/2024, where the GB of Ward number 18 Dimapur has requested the applicant to undertake immediate repair and renovation of the main gate to avoid any untoward incident. And also to take necessary action. This for covering the plinth.
Lordship, the foundation, Lordship, of the gate, Lordship. That's that's in question, Lordship.
And also, what is the last? And also to take necessary action to avoid water clogging so that the place does not become a breeding place for mosquitoes. Mr. So-and-so, learned counsel for the respondent petitioner, on the other hand, has filed an affidavit objecting to the application submitted by the petitioner. Objecting to the application submitted by the petitioner and submitting that the ground situation as per the photograph enclosed by the writ petition by the applicant and the petitioner opposite party is quite different. The learned counsel for the opposite party petitioner accordingly submits that it will be proper and in the interest of justice to allow the deputy commissioner to verify the spot and to ascertain as to whether the claims made by the application is valid. the learned counsel for the parties. In order to enable this court to pass necessary orders, it would be only proper to direct the deputy commissioner to verify as to whether the main iron gate of the premises covered by Pata number 1368 under Dock number 1425 of Dimapur Town Block number 7 and the lift shaft on the ground is required. Requires is not is required, requires repairing and whether the lift shaft on the ground is to be covered so as to avoid accident and to avoid breathing place for mosquitoes. The Deputy Commissioner Dimapur or the authorized officer shall accordingly verify as to whether the repairing shortfall by the applicant will be necessary. Taking into consideration that in the main writ petition, a status quo order has already been ordered. The Deputy Commissioner or the authorized representative, while undertaking the verification, shall also take note of the notice dated 27/7/2024 issued by the GB ZC Ward number 18, Dimapur. Stop. The report on the verification shall be submitted to this court within a period of 2 weeks from today. Mr. V. Jumomi, the learned government advocate, shall furnish a copy of this order to the Deputy Commissioner Dimapur for compliance. Deputy Commissioner is to verify, not you. If we give a prolonged time and then if in the meantime something happens to the gate, it endangers people's life, that may also, I think, we all have to take those into consideration. Listed after 2 weeks. Stop. A copy of this order be furnished to Mr. V. Jumami, learned government.
Lordship, with the Lordship's permission, Lordship may also kindly consider that there's some slab to be covered on the drainage also. My apologies, but Lordship.
That is on the ground shaft, you were saying?
Ground shaft and drainage.
Slowly, you are.
No, Lord.
Obliged, Lordship.
Bless my Lord.
For motion, item number 3.
My Lordship. Lordship, there's an application raising objection on the maintainability of the writ petition, Lordship.
Why?
Lordship, otherwise I have filed my affidavit in opposition. But Lordship, I'm going through the petition again, Lordship. At this juncture, which I wanted to raise the maintainability of the writ petition on the ground that the petitioner has no locus standi to file this application since the petitioner, Lordship, the gist of the case is that the petitioner has filed a writ petition 269 of the 269 of 2023 on the ground that the challenging the appointment of the respondent number 5, that is applicant, Lordship.
You are the respondent number 5.
Lordship.
You are the respondent.
But Lordship, in my affidavit also I've stated that the petitioner is claiming for post of MTS on the ground that he is a landowner. But whereas the father of the petitioner has already availed the opportunity and he was appointed, Lordship. He has availed the government servant and he has been appointed. And Lordship, as per the OM, Lordship, of 5th March 2018, which is categorically stated in the paragraph 3.6.
You can hear the objection raised by you while disposing the main writ petition.
Lordship.
May I please, Your Lordship? Your Lordship, I just wanted to give one submission in regard to this petition, in regard to this IA. My Lord, from para 1 to 3, I don't have any objection because in their affidavit in opposition, they have made the same statement. So I've replied on that. So let this matter be heard during the course of the hearing. And then now, my Lord, coming to para number 4, at Roman number 4, at page 10, the private respondent has stated that the petitioner has not challenged the approval order, which is annexed in their annexure at page 26, Lordship. Your Lordship, here at the time of filing this petition, since the approval order was not readily available, hence the petitioner had challenged the impugned appointment order of the private respondent, which is the final. So, Lordship, if recording, then
You are challenging his appointment. You are challenging his appointment.
Yes, Lordship.
Yes, Lordship. Yes, Lordship.
Stating that you are landowner.
Yes, Lordship.
Okay. Heard, Mr. So-and-so. Psycho 40, then counsel for the petition.
Lordship, I'm for the respondent 5, applicant. Yeah, applicant I.
So, applicant / respondent number 5.
Lordship.
The application raising objection on the maintainability of the writ petition shall be taken up together along with the amendment.
Much
obliged.
For motion, item number 4.
May it please your Lordship. Lordship, this instead IA is filed seeking for implement of the district planning machinery as respondent number 7, Lordship, in the writ petition 178 of 2024, Lordship. Lordship, while this petition was filed, there was lapses on our part and we did not implement the respondent number 7. So if this petition.
You have made the district planning machinery respondent number 7 even before the order was by this court.
No,
What
Lordship.
more?
No, Lordship.
See
We
your
have.
course title. Your respondent number 7 is a district planning machinery.
Lordship, as per the order dated 23/8,
I
Lordship.
know, I have seen that.
Lordship.
You were asked to consider as to whether it would be appropriate to implement this district planning machinery.
Yes,
as a
Lordship.
party respondent. That's all.
Lordship. And Lordship, since the petitioner retired from the under the establishment, so we pray that they may be
Who
implemented.
is the district planning machinery? PEG is only an institution.
Lordship.
Who is the officer manning this office?
My apologies, Lordship. It should be the department, Lordship. However, in the order we have prayed for the officer, Lordship.
No, district planning machinery, is it an office?
Yes, Lordship. It's the office, Lordship, under
Who is manning this district planning machinery?
the district officer, Lordship.
Why don't you actually like bring that district officer? Think over district planning machinery, whether you can directly implement district planning machinery.
Lordship, since the petitioner, Lordship, here, it's a read matter, Lordship, and this is regarding the regularization, Lordship.
Well conversant with that. What about your other respondents? Just have a look.
Lordship.
The state of Nagaland represented by the chief secretary,
Lordship.
the commissioner and secretary to the government of Nagaland, Department of so-and-so, the principal secretary, development commissioner, finance commission, the deputy commissioner, PEG Nagaland, the additional deputy commissioner. So all these are actually offices. Whether district planning machinery,
Lordship.
whether notice can be issued direct to district planning or
Lordship.
I don't know. It is like saying to the PNR. Whether this will be correct.
Lordship, in that case, allow me to withdraw this IA, Lordship.
You
I'll
should,
make an
I think,
assessment.
the officer who is manning the district planning machinery PEG, I think that officer has to be impeded. Correct? That is what I feel. Like, for example, you cannot just implement the directorate of school education. There must be the officer, the head of the office who is manning that office.
Lordship.
The office has to be implemented to that officer. Correct?
Lordship.
So kindly implement the officer who is actually manning this office.
Lordship.
Okay.
Lordship.
MS.
Mika HIM, Lordship.
Mika HIME submits that she has instructions to withdraw the IA with liberty to file afresh. The IA is allowed to be withdrawn with liberty to file afresh.
Lordship, this item, Lordship, 5 and 6, they are analogous, Lordship.
5, 6.
Lordship.
Okay, 5, 6 also, ma'am, same order. Okay.
Much obliged, Lordship.
5, 6, all the IAs will be disposed as per with liberty to file afresh.
May I please, Your Lordship, I'm so sorry, in item number 3, there's an interim, Lordship.
Item 3.
Yes, Lordship.
In the main writ petition.
Yes, Lordship.
Okay, the interim order passed in the writ petition shall continue till the next return of. Okay.
Much obliged.
For motion, item number 7.
May I please, Your Lordship? Your Lordship, this instant writ petition is filed seeking the respondent authorities to regularize the service of the petitioner, my lord, as per the office memorandum 2015, my lord. The petitioner is a work church employee serving under the department of the executive engineer PWT Twinsang, my lord, since 1991. That is for 33 years as on date, my lord.
Okay. That makes sense. Learner counsel for the petitioner. The petitioner. No, by the order dated 29/11/1991. The petitioner was appointed as W/C Jugali in the scale of pay in the office of the executive engineer, PWD within bracket R&B Twinsa, Nagaland. Stop. The petitioner is serving in the post for 33 years and is due to retire in the year 2026. Stop. The petitioner, having completed 30 years of continuous service, submitted a representation dated 23/7/2024 to the executive engineer, to the engineer-in-chief, PWD Nagaland Kohima, for regularization of service. But the same has not been considered by the respondents till date. It is the case of the petitioner that she is eligible to be regularized in service in terms of the office memorandum dated 17/3/2015 issued by the government. Issue notice to the respondent returnable after 4 weeks. NS Inauli, then government application accepts notice on behalf of the state respondents. Therefore, no further notice may be issued. The learned counsel for the petitioner shall however serve the requisite copies of the petition to the learned government advocate
During the course of the, my lord.
in the course of the day.
Obliged, my lord.
For motion, item number 8.
That is a Lordship. Lordship, this petition is pertaining to constitution of VTP Management Committee of Jopo Village and Rebuttal District. Lordship, the petitioners before this Lordship challenging the impugned order of approving the
Where is that impugned order?
Lordship at Annex 1, page number 17. By this impugned order, Lordship, the respondent number 6 to 11 were names were approved. The fact of the matter is the selection process in respect of the petitioner's village is that the village council has not even convened a council meeting, nor the general public were notified for election of the members of VTP Management Committee. And the petitioner has also written a complaint before to the respondent number 3, that is Deputy Commissioner, as well as the respondent number 4, that is Administrative Officer ADC Sanis, against the selection process. That has not been considered, Lordship.
But Mr. Your W.R. Muli.
Lordship.
But Mr. W.R. Muli, the learned counsel for the petitioner. The present writ petition has been filed. To question set aside the order dated 1/7/2024, issued by the Office of the Deputy Commissioner, Oka Nagaland, appointing the respondent number 6
to 11
as members of the VDP Management Committee, Support Village for a period of 3 years from the date of, that is, within a period of 3 years, that is from the date of issuance of this order up to
1 July.
Just wait, 1/7/2027. It is the case of the petitioner that the appointment of respondent number 6 and 7 as members of the VDP Management Committee.
I beg your pardon, Lordship, 6 to 11.
6 to 11.
Lordship.
It's not in accordance with the rules provided under the Nagaland Village Council Act 1978, as well as the Village Development Board Model Rules 1980. Stop. Issue notice to the respondents, returnable after 4 weeks.
Lordship, I have an interim prayer here, the petition.
No,
Tin
this
depan
is-
nasi.
the appointment is made
Lordship.
1st July.
1st July 24.
Yes. What was the last? 4 weeks. MS Pichano, learned government advocate, accepts notice on behalf of respondent number
1 to 4.
1 to 4. Therefore, no formal notice need be issued to the state respondents. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate within
In the course of the day.
in the course of the day. Stop insofar as respondent number 5 to 11 are concerned. The learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within a period of
3 days.
3 days from
From-
today. The prayer for the interim shall be heard on the next return of the page.
For motion, item number 9.
May I please, Lordship? Lordship, this is pertaining to appointment on land ownership basis. Lordship. The petitioner is one of the descendant, the grandson of one of the landowner who have donated the plot of land where
Where is the impugn order?
the impugn order, Lordship, is at page number 45, Annexure G. This is by the same order, Lordship, page 45. Annexure G, Lordship. The type copy at page 46, Lordship. This, the petitioner is challenging this order in respect of serial number 4, Lordship. By the same order, 5 persons were appointed. However, the petitioner is challenging the in respect of serial number 4. That is, there is here in the petition respondent number 4, Sri Edward E. Humzoy, medical attendant, Sunny CHC. As far as the petitioner is concerned, though he has applied the both of a medical attendant on land ownership basis by furnishing all the documents, land ownership. However, the respondent number 4 was appointed in, instead of the petitioner. The respondent number 4 is not a land owner. And the petitioner has not, from the family, has not availed any opportunity.
Mr. So. Learned counsel for the petitioner. Stop. The present writ petition has been filed, challenging the order dated 5/11/2023, issued by the Principal Director, Directorate of Health and Family Welfare, Nagaland, Kohima, appointing the respondent number 4 to the post of medical attendant at Sanis CHC. It is the case, stop. It is the case of the petitioner that the respondent number 4 is not a landowner and therefore not eligible to appoint it, and not and to the respondents, returnable of the folks. MS. So and so. Then the government advocate accepts notice on behalf of the respondent number 1, 2, and 3.
Yes, Your Lordship.
Therefore, no formal notice need be issued. The Illinois Counsel for the petitioner shall however serve the requisite copies of the writ petition to the Illinois government advocate within
In the course of the day, Your
in
Lordship.
the course of the day. So insofar as the respondent number 4 is concerned, the Illinois Counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post week 80 within a period of
3 days.
2 days from today.
Lordship, I have an enjoyment that may be considered, that may be taken up on the
So
next.
somebody is appointed, let us consider your
Okay.
case. on that.
Obliged.
For motion,
Obliged.
item number 10.
May I please, Lordship? Lordship, here I'm seeking for appointment on commissioned scheme. My late father died on harness on 28th of March 2016. And I've submitted my application on 22nd of April 2016. And my application was forwarded in the year 2019. However, till up to date,
Your application for appointment was submitted on 22/4/16.
no, Lordship. 23/8/2016.
Where is that? Your father died on 28/3/16.
Yes, Lordship.
Where's your application?
My application is at page 16.
16.
Yes.
When is your application dated?
28,
No date.
22/4/2016.
What happened to this?
Lordship,
What happened to your application?
till up to date, even after a span of 8 years, my application for commissioner appointment is still yet to be considered.
You submitted just one representation and then
No,
you had
Lordship.
also slept over?
My application was forwarded in the year 2019 by the Superintendent of Police, Wokha.
Superintendent of Police.
Yes.
Where is the forwarding?
On 23rd of August, in Annexure E,
Next page.
page 21.
This
And
is
yes, I was at serial number 1 to the Director General of Police.
That's Mr. So-and-so. Then counsel for the petition. The present application has been filed. Seeking appointment on Commissioner Bureau. Stop. It is the case of the petitioner that his father, who was serving as regimental number 606, rank Naik, under the Superintendent of Police, Wokha, Nagaland, died in harness on 28/3/2016. Subsequent thereto, the petitioner submitted the application dated 22/4/2016 to the Superintendent of Police, Wokha, Nagaland, for appointment on compassionate ground. So the application submitted by the petitioner was forwarded by the Superintendent of Police, Wokha, Nagaland, to the Director General of Police, Nagaland, Nagaland, Kohima, by the letter dated 23/8/2019. Stop. Over till Mr. So-and-so, the legal counsel for the petitioner submits that in terms of the office memorandum dated 17/9/2015, issued by the government, the petitioner is eligible to be appointed on compassionate ground. Stop. Issue notice to the respondent, returnable after 4 weeks. Mr. So-and-so accepts notice on behalf of the state respondents. Therefore, no formal notice may be issued. Stop. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate within
2 days.
Within a period of 2 days from today.
For motion, item number 11.
Lordship, here also I'm seeking appointment on compassionate ground. However, here I'm challenging the appointment of private respondent number 6 as well. The approval as well as the appointment order. Here, the petitioner led father was serving as Chokidar under the establishment of SDO Aboy. Put in harness while rendering as night Chokidar on 3/9/2023. And I've submitted my application dated nil, and which was also forwarded by the SDAO Aboy to the Director Agriculture. However, without considering my application, the director has appointed the private respondent 6 in the vacancy arose by my late father.
Where's that in order?
28/6/2024. Page 21. Annexure E.
Mr. So-and-so. Learned counsel for the petitioner. The case as projected by the learned counsel for the petitioner is that the petitioner's father died in harness on 3/9/2023 while serving as night chowkidar at Agri Office under the establishment of Sub-Divisional Agriculture Officer Abuimon, Nagaland. Subsequent to the date of the petitioner's father, the petitioner submitted an application dated May to the Director of Agriculture, seeking for appointment on compassionate ground. Stop. The Sub-Divisional Officer Abui had also strongly recommended the case of the petitioner for appointment on compassionate ground. It is the case of the petitioner that he has a right to be considered for appointment on compassionate ground in terms of the office memorandum dated 17/9/2015 issued by the government. Stop. However, instead of considering the appointment of the petitioner, the government has issued a notification dated 28/6/2024, appointing the respondent number 6, appointing the respondent number 6 as multitasking staff in the office of the Subdivisional Agricultural Office, Abui. Stop. Being aggrieved, the present writ petition has been filed. Issue notice to the respondents, the returnable of the forms. Mr. So-and-so, when government advocate accepts notice on behalf of the state respondent number 1 to 5. Therefore, no formal notice need be issued. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate within 2 days, within a period of 2 days from today. Stop. Insofar as respondent number 6 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within a period of
3 days.
3 days from today.
Oblige. For motion, item number 12.
Please, Lordship. The petitioner here is claiming for appointment on land ownership basis. The petitioner is the landowner where the Tamkong Sub-Center under Chief Medical Officer Mon is established. The land was donated by the petitioner's grandfather. And at
What is the impugn order?
Impugn order is at page number 19 and Annexure D.
19.
Yes, ma'am.
Page 19.
The appointment of the private respondent number 5 was made. He is not a landowner, nor his appointment was made without following any selection process, ma'am. Then there was an oral agreement, and then to that extent, the living witnesses has also issued a certificate certifying that there was an oral agreement between the landowner and the.
Mr. Learned counsel for the petitioner. By filing the present writ petition, the petitioner has impugned the order dated 18/1/2023, appointing the respondent number
5
as medical attendant at Tamok Sub-Center under the establishment of Chief Medical Officer Mon. Stop. It is the case of the petitioner that the respondent number 5, correct?
Yes.
Is not the landowner and therefore could not have been appointed to the said post in question. Denying the case of the petitioner, who is a landowner. Issue notice to the respondents returnable after 4 weeks. And then Mr. So-and-so accepts notice on behalf of the respondent number 1, 2, 3, and 4. State respondent number 1, 2, 3, and 4. Therefore, no formal notice may be issued. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate within
2 days.
Within a period of 2 days from today. Insofar as the respondent number 5 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of
2 days, my lord.
2 days from today. Okay.
My lord, I have an interim period, my lord.
The appointment was
no,
made.
I'm not asking for stay of the appointment order. I just want to stay not to regularize the service of the respondent number 5 during the pendency of the writ petition, my lord. I have made a specific
Let's see
period.
the appointment order first.
Yes, my lord. Annexure D. The respondent number 5 has been appointed, and then the appointee is on contingency period for a period of 2 years.
No, it's on probation. It's a regular appointment.
Yes, but his service is yet to be confirmed. Condition number 2, the appointee shall be on a probation for.
Respondent number 5 shall be subject to the outcome of the writ petition.
For admission, item numbers 13 and 14.
If I may.
Why always this? Why? This is addressed to. This is addressed to. This is addressed to. Addressed to. Who? No, this is addressed to the bench section, Kohima bench.
Sorry, Your Honor.
Yes.
Your Honor, I have received the reply from OP number 7. I would like to request some time to prepare my rejoinder.
Madam, have you submitted your, what were you supposed to submit? Written objection?
Yes, Lordship, I filed it on 27th August. Copy has also been given, furnished, Lordship.
Let the written objection be filed. Yes, what is your prayer now? Yes, ma'am.
Your Honor, I
What is-
have received it. I have received it yesterday. I would like to prepare my rejoinder and submit it to the registry, and also to serve notice.
You want to reply to the objection filed by the respondent?
Yes, Your Honor. I would like to file my rejoinder, Your Honor.
Rejoinder.
So if you could kindly give me enough time to prepare.
How much time you require?
6
Madam,
weeks, Your Honor.
at least 3 weeks time.
Yes,
How much
6
time?
weeks.
There's something wrong with the connection.
6 weeks, Your Honor. 1 month and a half. Am I
Something wrong?
audible now?
Now audible, yes. How much time you require?
6 weeks, Your Honor, please. 6.
6 days.
Am I audible? Weeks, Your Honor.
Yes.
1 month and a half, Your Honor, please.
1 month and a half.
Yes, please.
Where is the objection filed by you, madam? Which date you had filed that objection?
27 August, Lordship.
27 August. Let us see. August.
Your Honor, I received it on September 15th.
Yes, we
27th August, Lordship.
27 August.
In fact, that day I had a copy for ready for them also, but they appeared online, Your Lordship.
They said they have received.
Yes.
So that is 20. I'm just trying to trace out your 27 August. 27 August.
Lordship, yes.
It was filed by respondent number 7. You filed it as a titled it as an affidavit in opposition.
Yes, Lordship.
So, madam, you want to file a response to this affidavit in opposition, filed by the respondent number 7.
Yes, Your Honor, I would like to file my rejoinder.
Yes, you're appearing for, Learned Counsel, you're appearing for?
I'm appearing.
The other counsel.
Your Honor.
My lord, I am appearing for the respondent 1, hospital. Christian Institute of Health Science and Research. I am representing respondent number 1 for the main writ petition.
Do you have anything to say on the affidavit in opposition filed by the respondent number 7? Anything?
Yes, my lord. Actually, there is a blanket order against the institution that you have to continue the treatment till further orders, and your claim petition can be kept pending, and we will give necessary orders. This decision has been taken on an emergency basis to save the baby. My lord will accept that now the baby is grown. My lord, the reality is now we have spent already 1 crore 7 lakhs towards the health expenses for the baby, my lord. We duly respect the orders of the High Court. At the same time, my hospital is a purely private hospital. The Chief Secretary of the state is a honorary person who is appointed under the Societies Act. It is not at all, no share from the government of Nagaland or state of Nagaland, my lord. It is purely private hospital. So we have already suffered a financial crunch, and this can be helpful to the other people also, other poor people. Now we are locked, my lord. So unless you alter the order issued in 18/2/2022, my lord, 18/2 on the main writ petition.
Your Honor, I
Last
object to that. If the
1
baby
minute, 1
is
minute. Let me
thought
complete.
she
Let
would
me
die.
complete. Let me complete. Let me complete.
Sure, go ahead.
Let me complete, please. My lord, unless the orders issued in 18/2/2022, last paragraph that we have to continue the treatment. We are awaiting that order till, but this is now 3 years, my lord. We have been spending so much. I am submitting this. I am submitting this before the my honorable lord.
Learned counsel, we will come to the issue. We will come to that issue.
Yes,
but
yes, yes, my lord.
Let us first dispose of the allegation made against the respondent number 7. Let us first dispose of that application, the miscellaneous application. Only thereafter we will come to, but not today, because today the counsel for the petitioner is praying for 6 weeks time to file a rejoinder to the affidavit in opposition filed by the respondent number 7. So
I fully respect the observation of my lord.
Yes, sir. Yes, madam. Anything to say?
Your Honor, I would just like to file my
Please,
rejoinder.
The learned counsel for the hospital has expressed that keeping the baby has a incur more financial burden on the hospital. So taking into consideration of everything for the hospital, even for the baby also, I think 3 months, 3 weeks will be appropriate for the petitioner to give response so that we dispose the petition at the earliest. Otherwise, your lordship knows that no right is absolute. Even the state or whatever has restricted financial problems. So your lordship, no right is absolute.
What disturbs the mind of this court is the baby.
Of course, it's a
See,
baby,
what
but your lordship.
disturbs the mind of this court is the baby.
Yes.
Of course, the petitioner has not. You're right.
Yes.
The petitioner has no absolute right to say that the baby should be taken care of by a private hospital.
Exactly, lordship.
Perpetually.
Yes.
That right doesn't. But
yes.
Anyhow, I think this. I think we will have to consider in the larger context,
lordship.
taking into account the law laid down by the Supreme Court. Also, I think there are many laws on treatment, pre-medical treatment, and all this. So I think we will have to take all these things into consideration. Okay, madam. Yes, where's the petitioner? Where's the petitioner? Yes. We grant you 4 weeks time, not 6 weeks. Okay.
Thank you, Your Honor.
4 weeks time.
Yes, Your Honor. Your Honor, thank you.
Your good name?
Barbara Nunes.
Just with me. Mr. MS, madam, you're Barbara Nunes. Barbara Nunes, your good name? Yes, madam. Name of the petitioner. Are you
I only know her by Barbara, Your Lordship.
Okay, here, Barbara. Heard MS Barbara Nunes, petitioner in person, who seeks for 4 weeks' time to file rejoinder to the affidavit in opposition filed by the respondent number 7 in IA number 65/2024. Prayer is allowed. 4 weeks' time is granted to the petitioner in person. 4 weeks' time is granted to MS Barbara Nunes, the petitioner in person, to file the rejoinder within the period of 4 weeks' time. Listed up to 4 weeks.
For motion from the supplementary cause
Thank you,
list,
Your Honor.
number 33.
Yes, we have listed up to 4 weeks. This is item number 4.
May it please Lordship. Lordship, I'm serving as a bus conductor at Saujang College, Train under Higher Education Department, Lordship, on work church basis, Lordship. I have completed 31 years of service, Lordship. However,
in the same capacity?
Yes, Lordship, in the
On
same
contingency
capacity.
fixed pay?
Yes, on work church basis, Lordship. Initially, my appointment was on contingency basis. Subsequently, I was appointed on work church basis, Lordship.
With a scale of pay?
Yes, Lordship, scale of pay, Lordship. Now I've completed 31 years of service on 1st June 2023, Lordship. I have also made a representation before the authorities, Lordship, on 12th of June 2024, Lordship.
Where is your representation?
Lordship will find page number
This way.
20, Lordship. Page number 20, Lordship. My case is squarely covered by the Office Memorandum 2015, Lordship.
Mohammed, the learned counsel for the petitioner. It is the case of the petitioner that he was appointed as a bus conductor on contingency fixed pay basis on 1/6/1993. And thereafter, by order dated 31/8/1995, the petitioner was temporarily appointed as a bus conductor on work charge basis. On work charge basis. On work charge basis. Okay. It is the case of the petitioners that having served the institute for 31 years, the petitioner has a right to be regularized in service in the light of the Office Memorandum dated 17/3/2015 issued by the government. So, the petitioner submitted the representation dated
12/07/2024, Lordship.
12/07/2024 to the Director, Higher Education Department, Nagaland, Kohima, for regularization of his service as bus conductor at Sau Chang College, Kohima. However, the representation submitted by the petitioner does not evoke any response. Being agreed, the petitioner is before this court. Issue notice to the respondents, returnable after 4 weeks. Yes, and so, learned government advocate accepts notice on behalf of
all the respondents.
the state respondents, and therefore no formal notice need be issued to the state respondents. The learned counsel for the petitioner shall however serve the requisite copies of the written petition to the learned government advocate
In the course of the day.
in the course of the day. Okay.
Obliged.
We resume at 2.
Lordship, indulgence, Lordship, mention item 32, last hearing item, the other hearing item might also, it may not reach. Thursday, Your Lordship, I have taken the consent. Item 32, last hearing item, there are other hearing matters also. Item 32. Thursday, Your Lordship. I've taken the consent.
Okay. On the prayer of the learned council for the purpose listed on
Thursday.
19.
Your Lordship.
Listed on 19, 9/2020.
Obliged, Lordship.
Lordship, item 15, it seems their respondents are going to pray for time, so kindly pass that order. I have some problems in the afternoon.
Item 15.
Yes,
Lordship.
the next item, because till item 14, your Lordship has taken up.
Item 15. Yes,
At 3 weeks' time, may kindly be granted, my lord.
Mr. N. Angami, okay. The letter senior government advocate is allowed 3 weeks' time to file affidavit in opposition. Stop. The same is not objected to by Mr. Takamasa, learned senior counsel.
Lordship, thank you so much, Lordship.
Okay. Yes.
Lordship.
At 2.
Mention Brian.
Right, mission as it were. Supplementary debate as it were. Mission. Right, or matter of order. The division, my combination for that number 16, no? City that 15 division, information. Row city information, no? Division. Oh, cha. Oh, cha. Why do within the Jana? Itu sebenarnya itu tidak. Maaf, cuma macam apa? Tahu rasa lah. You can do it this year or you can do. I love traveling this. Starting in Where is the
Yeah.
For admission, item number 16.
May I please, Your Lordship?
Yes.
Your Lordship, here, kindly let this matter be listed after 3 weeks, Your Lordship. Here, the
What?
pleadings are complete, Your Lordship, so for admission hearing after 3 weeks, Your Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed. And therefore the matter can be listed for hearing in the usual course. Okay.
Obliged, Your Lordship.
For admission, item numbers 16, I beg your pardon, 17 and 18.
Please, Your Lordship. Here I have received instructions in 236, WPC 236. However, important documents are yet to be furnished by the responding authorities.
What about 321?
I'm yet to receive instructions.
May I please, Lordship?
Lordship, here I am appearing on behalf of Apila Sankam.
Okay.
She's in disposed Lordship. In item number 17, she is representing respondent number 10. And in item number 18, she is representing respondent number 9. And Lordship, she has received, I was informed that she has received instruction. So 3 weeks may be granted to file her affidavit in opposition in both the items, Lordship.
Lordship, last chance has been given several times. So even in the previous order, the court has.
What is the case?
I'm claiming for damage and land compensation.
Your Lordship, this is for proposed to construction.
In both in 321 and 236,
NH02.
we are praying for proper implementation of provisions.
Who is for the union?
In
CGSC.
yes, in 236, it's Zeren Muli, and in 321, it's YP Gupta. They have accepted notice. But despite of several reminders, they never appear, Lordship.
In 321, Mr. LT, you have not received
Your Lordship. And in 236, I have received. However, important documents I'm yet to receive.
what is that important document?
Land survey map. They are yet to furnish me by the concerned respondent authorities.
Heard MS Swenso, learned counsel for the petitioner. Mr. LT Sanctum. For the respondent, for the state respondent. And Mr. So-and-so on behalf of MS Apila Sanctum, respondent number 10. This is in 321, okay? None appears for the Union of India. No. No, cancel that. Only the name of the council heard, Mr. So-and-so. So-and-so, MS so-and-so, Mr. LT Sanctum, so-and-so, and so-and-so. And none appears for the Union of India. None appears for the Union of India. By the order dated 23/8/2024. This court had granted 3 weeks time to the respondents to come up with an instructions and file their counter affidavit. It was observed that if the same is not filed within the next 3 weeks, court may consider passing of parade orders. Today, when the matter is listed, the Learned Counsel for the state as well as for the respondent number 10.
In the PPC 321 of 2023.
6 for some time to file their counter affidavit. Stop. In view of the order dated 23/8/2024 passed by this court, a last chance of 4 weeks is granted to the respondents to file their respective affidavit, failing which it is made clear that necessary cost shall be imposed on the counsel for the respondents and on the counsel for the respondents, on the learned counsel. The necessary cost shall be imposed on the learned counsel representing the respondents or the parties concerned. Okay. Please file your affidavit. Next time, not less than 10,000, keep in mind.
For admission, item number 19.
Yes.
May it please, Your Lordship. Lordship, I am for the respondent in this IA. Due to unavailability of my senior counsel, Ms. Noksang Tila, on account of her being out of station, this matter can come up on 24th, that is next Tuesday, 24th of September.
Yes. Mr. So-and-so makes a mention on behalf of MS Noksang Tila, learned counsel for the petitioner, and seeks adjournment of the case after a week. Prayer is allowed. Listed at court.
Lordship, if it can be put on Tuesday.
No, we don't
24th.
fix date. If we fix date, nobody is coming.
Nice, Lordship.
For admission, item number 20.
Same, item 20, same order.
For admission from the supplementary course list, item number 34.
Yes, please, Lordship. Lordship, my senior, Mr. Imti Longjun, he has some difficulties today, Lordship, so if this matter can come up after the puja break.
MS so-and-so. We could so no.
Yes, Lordship.
Learned counsel makes a mention on behalf of MT Longjun, the learned counsel for the petitioner,
Petitioner.
and seeks adjournment of the case after 3 weeks. Prayer is allowed. Listed to court.
Lordship, there's an interview, Lordship.
Stop. The interim order passed earlier shall continue till the next return of the week. Okay.
For orders, item numbers 21 and 22.
Yes.
May I please, Lordship? Lordship, in item number 21, the notice for respondent 7 to 13 is evaded.
That was the last, even the last order passed.
Lordship, I have been instructed to appear for the newly implemented respondents. In both the
7 to
cases.
13?
In both the cases, yes.
7 to 13.
Mother.
And in this.
In both the cases.
In item
Private
number.
respondents.
Yes, Lordship.
Private respondents. Have you filed your power?
I will be filing tomorrow, by tomorrow.
Mr. Yamarwati, the learned counsel submits that.
he has been entrusted to appear for the private respondents in both the writ petitions, and he will be filing power by tomorrow. That is, by tomorrow means
18.
that is 18/9/2024. Listed after 3 weeks so as to enable Mr. Gauhati, the learned counsel for the private respondent, to file affidavit in opposition. Yes, Mr. Veto, have you filed your affidavit? in opposition?
No, in the earlier petition, they have filed.
What about the other?
In both,
In both?
For orders, item numbers 23 and 24.
May I please, Your Lordship?
Yes.
Your Lordship, in item number 23, I have sent for the waiting of my affidavit. So the matter will be fixed on the next date on any day. Item number 23,
Mr. This is in a.
review. Your Lordship.
Mr. M. Timso, the learned additional AG submits that the affidavit has been sent for waiting in review petition 5/2023, and therefore the matter may be listed after a week. Prayer is allowed.
Lordship, a date may be fixed.
Lordship, in item number 24, I'm yet to receive an instruction.
Let this be listed on the next date. We'll see.
Okay. Lordship.
Lordship, can it be a fixed date?
Listed on
24th, Lordship, Tuesday?
No. 3/10/2024.
Lordship.
In the meantime, you file your affidavit also.
For orders, item numbers 25 and 26.
May I please, Lordship.
Yeah.
My lord, I pray that we may be given another 3 weeks' time to file our Bakalat Nama as well as affidavit in opposition.
Why Wakalat?
We're yet to file our Bakalat Nama.
Why? At least affidavit in opposition, okay, that's a different matter, but why Wakalat Nama?
We'll be filing shortly, my lord.
Lordship, in my writ petition WPC 234, there is an error. It has been accidentally in paragraph 3. It has been accidentally entered as legal owner instead of lessee. So, if I may be allowed to file an IA to amend my petition, Lordship.
In both the cases,
Yes, we're,
in 226
Yes,
and
yes.
234.
yes, in both the cases. For respondent number 1 to 3, my lord.
Your rectification is in 234.
Your Lordship.
234, which para?
Para 3, Your Lordship. Page number 5, Your Lordship. I have stated absolute and sole legal honor. I wish to rectify that, Your Lordship.
Who's for the state?
Yes, we are for the state, my lord.
You're for the state.
My lord, my lord.
MS Renzo, learned counsel for the petitioner submits that she may be allowed to file an application for rectification of some defects made in paragraph 3 of the writ petition. Where is allowed? Petitioner is allowed to file application for rectification of the defects.
Your Lordship, status quo may be maintained as of today.
Mr.
B Soto, my lord. B Soto.
V. Solo.
B Soto. Soto, S-O-T.
V. Soto.
My lord.
The learned counsel for the
Respondent number 1, 2, and 3.
in both.
In both the, yes,
The
2 to 6 and
learned counsel for the state respondents. is allowed some time. Is allowed a week's time to file power for representing the said respondents. This is the case of the 3 weeks.
Your Lordship, interim order.
Which, in which?
266, 266, Your Lordship.
266.
Yes, Your Lordship.
By which order?
Your Lordship, by order dated 23rd March 2024. Your Lordship, in regard to respondent number 4, we have taken fresh steps by way of registered post to serve notice, Your Lordship. If necessary, order may be passed again, Your Lordship.
Respondent number 4, in which case?
Your Lordship, WPC 266 and 234, both the case, Your Lordship.
Respondent number
4. The CEO, Hotel Polo Towers, Your Lordship.
Where is that interim order? I'm not getting it. Where is, which order?
Your Lordship, 23rd for 2024.
23-4.
Yes, Your Lordship. Pardon me, Your Lordship, 15/12/2023. My apologies, Your Lordship. Status quo to be maintained, Your Lordship, 15/12/2023.
The status quo order passed on 5/12/2023 shall continue till the next returnable date. The Learned Counsel for the petitioner shall take fresh steps for service of notice upon the respondent number 4 in both the writ petitions.
Your
In
Lordship,
both the writ petitions.
yes, Your Lordship, Your Lordship, we have taken fresh, we have served the notice. So there's an order dated in regard to the service upon respondent number 4. So they have received, but there is no response from the part, Your Lordship. Office, there is an office order, Your Lordship.
The last line, please.
You take fresh steps.
Lordship.
Yes, what was the last order? By registered post with AD within a period of 7 days from today. Okay.
Lordship.
Take
Much
fresh
obliged,
steps.
ma'am.
Then only thereafter we'll pass orders. Okay.
Much obliged.
For hearing, item number 28.
Some other case. Yes. My lord, the petitioner is the wife of one Shuli Ma. Page 10 is the appointment order.
This is wrongly listed. It will be appropriate for this court to take up the present case only after the disposal of the pending SLP before the Honorable Supreme Court.
Some similar matter was been referred to the SLP. Similar
this-
subject matter.
Tell this bench assistant at least to read the order properly. At least they are educated and qualified. Before we pass any stricture. Yes, what about the particulars of the case? Yes, sir. In the Supreme Court, the learned government advocate is directed to place the particulars of the case which has been filed before the Honorable Supreme Court. Did you get the particulars?
No. Lordship, but I.
Don't sleep over the orders passed by this court.
No.
Next time we'll impose course on you, not on the government. On the next date fixed, Mr. V. Jimomi, the Lieutenant Government Advocate, shall place the particulars of the case which has been filed before the Honorable Supreme Court of India and also the status report of the said case as ordered by this court on 13/8/2024, listed after 3 weeks.
For hearing, item numbers 30 and 31.
So what is this? What is the matter?
The main issue is the petitioner is the asthmatic person. Earlier, it was litigation before this honorable court. Then he was reinstated. Then that his discharge period, that is 15/5/2010 to 19/9/2015, was treated as none. So the petitioner filed the PPC 17K of 2017. In the single bench directed to pay the amount. And this was filed in writ appeal 3K of 2018, which was dismissed in. Again, what happened is that The petitioner was directed to recover an amount of rupees 7 something, as saying that it was illegally. It says paid. So the petitioner is before this court in 280.
What is your main grievance?
Graphic maximal.
What is your main grievance?
My lord, they cannot make that recovery. What they have made to me, they cannot make recovery to
Why?
that. Because the petitioner never misrepresented. There is no illegality in it for the reason that this amount was never as the salary of the petitioner for that particular point of time. It was only the pay refixation, 7 pay commission refixation. Instead of this honorable court directing to pay the error salary from 15/5/2010 to 19/9/2015. Instead of what they have given is only the
Yes,
way,
we'll list it next week.
my lord.
Lordship, this WBC 212 of 2022 be taken up first. If he succeeds in the case, then automatically
212.
yes.
212.
We'll list it next week. 212. Let us see.
That is illegal termination.
If you succeed, then you will eventually succeed in the this other petition also.
212.
At the learned counsel for the parties. Listed again after.
March.
Yes, next.